Subpart B, hazardous material penalties. 209-101, simple penalties generally. 209-101, 201-203, 209-121, to prescribe the rules to assessment of civil penalties pursuant to the Federal Hazardous Material Transportation Safety Law, Title 49, U.S. Code, Chapter 51, with the effort of the brief and the belief of the person who knowingly committed the act of the violation of any provision, Subpart B and C of the B and C of the Chapter 1, Subpart Title D of the Title of the effort, exception for the enforcement of reliable, responsibility, any of the waivers or an issue thereof after thereunder they may conduct with the proceeding to assess the civil penalty. 209-103, minimum maximum penalty. The person knowingly violates the requirement of the Federal Hazardous Material Transportation Law and in order to issue thereunder is A, Subpart A, Subchapter A or C with the Chapter 1, Subtitle B with the title of the or on a special permit that approved the issue under the Subpart A, Chapter 1, Subtitle B with the title of the liable civil penalty of no more than $75,000 each the violation, except for the maximum civil penalty for the violation. $175,000 violation result of the death and serious illness, severe injury of any person, substantial destruction of the property, the minimum of $450 civil penalty applied for the violation related to training when the violation continued the one each of the day of the violation constitutes a separate offense of Title 49 U.S. Code 5123. Maximum minimum civil penalty described in paragraph A of section applied with the violation occurring on after the Act of 2012. 2009-105, the notice for the probable violation, the effort through the chief of the council to begin the civil penalty proceeding with the service of note for the violation, the only the person charging him or her with the violated one or more provisions, subpart chapter A1, A or C with the chapter 1, subtitle B with the title of the appendix B with the subpart contained with the guideline U with the chief counsel to make an initial penalty assessment. The notice for probable violation issued with the section includes same with the provision with the respondent believed to be violated, to the same with the actual allegation upon the proposed civil penalties to solve the notice for the maximum amount of the civil penalty for the respondent may be liable. Notice for the amount of the civil penalty proposed and set for the description of the manner with which the respondent should make the payment of any money to the United States, the same as if the respondent provides the pursuant present the written explanation, information, and the materials and for the charge of the mitigation of the penalty statement of the respondent the rights of the request for the hearing of the procedure for requesting the hearing the FRA made with the amendment with the notice for the probable violation any time prior to the entire entry order of assessing the civil penalty. The amendment contains any material allegation of the fact that the respondent, given an opportunity to respond and pending the notice of the FRA may change with the civil penalty amount with the proposed method into and including the maximum penalty of not $75,000 each violation, except with the violation resulting in death and serious injury, severe injury to any person, substantial destruction of property. The FRA may change with the penalty amount with the proposed up to and including to the maximum penalty of $175,000. 209-107 reply within 30 days of the violation of the service within 30 days of the service notice for the probable violation issued in 2009-105 the representative respondent may pay the provided in 209-109 thereby closing the case to make an informal response provided in 209-11 request for the hearing provided in 209-11-13. Chief of Counsel makes them the 30 days period of give to how shown. The respondent reply with this particular one of the three actions described in paragraph A of the section within the period probably constitute the waiver that his or her right to appear with the contest allegation authority with the Chief Counsel without further notice for the respondent to find the fact that the alleged notice for the probable violation to set for the appropriate civil penalty. 209-109 payment of the penalty with a compromised payment of the civil penalty may be made with a certified check with money or the credit card may be made with a certified check with money orders should be made available to the Federal Railroad Administration some of the FFR of the Mike Monroe Area Center General Accounting Division AMSC 300 PO Box 325082 the Oklahoma City Oklahoma 73-125 overnight express payments may be sent to the FRA of the Michael Monroe Area Center General Accounting Division. AMSZ 365 South MacArthur Boulevard, headquarters building in the rooms 176 Oklahoma City, Oklahoma 73-169. Payment of the credit cards must be made via the internet. www.paygov. Instructions pay online payment found with the website. Anytime the pay before an order assessment penalty is referred to the Attorney General of the collection with the respondent may offer the compromise specific amount with the contracting chief of the council. Alright, 209-111, informal response to the assessment. If the respondent elects to make an informal response with the notice of the probation, probable violation, respondent submit the chief of the council to submit such with explanation information on the material the respondent may desire with an answer for the charge for the mitigation of the proposed penalty. The respondent may include his or her informal written the respondent with the request for the conference with the receipt with such request for the chief counsel with the range of the conference pursuant to practical the time and place of the mutual convenience. Written explanation and formal material submitted by the respondent, relevant information presented during any conference under this section of the concern of the Chief Counsel reviewing the notice for the proposed violation, determination of the fact of violation, the amount of the penalty assessed. After consideration, formal response, including any relevant information presented with the conference, the Chief Counsel may dismiss the notice of the probable violation and hold in part. If he or she does not dismiss the whole, he should may issue an order assessing the civil penalty. Or 209-1113, request for the hearing. The respondent elected to request for the hearing. He or she must submit the written request and the Chief Counsel reference to the case number which appear with the notice of the probable violation. The request must state the name of the address of the respondent, with the person signing the request indifferent with the respondent, state with respect with the allegation whether admitted and denied, state with the particular with the issue with the brief, the respondent at the hearing. After the request of the hearing comply with the request of the paragraph A with the section of the Chief Counsel, schedule the hearing of the earliest practical date. Chief Counsel with the hearing officer is appointed in 209-1115 the grant extension for the time of the commencement of the hearing of the good cause shown. Alright, 209-1115. When hearing was requested to schedule in 209-1113, the hearing the official designated the Chief Counsel conveyed if the presiding officer presides over the hearing, the request that the respondent practicable the hearing is held in the general vicinity with the place where the eligibility violation occurred, that the place of convenient with the respondent, the testimony of the witness shall be given under the oath of the attorney, and shall be recorded verbatim. Presiding officials may have the administer of the oath on affirmative action issuing the submitting of the provided in 209-7 the adopt the procedure with the submission of evidence of the written form taken the cause of the disposition of it to be taken with the rules off the proof the receive the relevant evidence the examine of the witness of the hearing the convey the recess and reconveying of the judge adjourning the otherwise relegate the course of the hearing hold the conflict settlement of the simplification of the issue of any other proper purpose taking any other action authorized or by consistent with the provision of the subpart pertaining to civil penalties permitted by law which may be expedited by the hearing of the disposition issue the raised therein. The Chief of the Council has the burden to provide facts alleged by the non-notice of the proposed violation may be discussed with the relevant information necessary to fully inform the presiding officer of the matter of the concern. The respondent may appear with be heard on his or her on behalf of the counsel of his or her choice. The respondent, his or her counsel may offer the relevant information, including testimony when he or she believes she could be considered a defense allegation which may be bear of the penalty proposed and set the conduct cross-examination may be required the full disclosure of the material facts. At the conclusion of the hearing, assume thereafter of the hearing, the official should provide the party of the may file the proceeding proposed filing conclusion together with supporting reasons. Alright, 209-1117. Proceeding officer decision. After considering the evidence for the record, proceeding officer dismiss the noticeable probable violation and hold in part with the presiding officer that does not dismiss the whole, and he or she will issue the server on the respondent in order to assessing civil penalty decision. The presiding officer will include the same defined conclusions as well as part if the risk allows the reason for the therefore, with all the materials issuing the fact of law with discretion, and within 20 days after the service in order of assessing the civil penalty, the respondent does not pay the civil penalty, you file an appeal provided in 209-121. The case may be as provided in 209-1121. The case may be referred to the Attorney General with the request of the action collecting the penalty brought by the appropriate United States District Court. 209-11-9. Assessment consideration. Assessment of the civil penalty under statute 209-1117 is made only after considering the nature of the circumstance of the violation, examine the gravity of the violation, the degree of the respondent, the capability and the culpability of the respondent, history of the prior offense of the respondent, ability to pay, the effect of the respondent, the ability to continue with the business, such other measures of the justice may require. Alright, 209-121, appeal any part of the aggravated with the presiding officer decision of the order issued with the 209-1117 assessing the civil penalty may file an appeal within the administrator of the appeal, and it must be filled within 20 days of the service of the presiding officer prior to rendering the final determination of the appeal. The administrator may be remand the case for the further proceeding before the hearing officer. In the case of the appeal with the respondent with the administrative firm, the assessment of the respondent does not pay the civil penalty within 20 days after the service of the administrative decision to appeal the matter of the may be referred to the Attorney General with the request of the action of the collection penalty to be brought through the appropriate United States District Court. Alright, criminal penalties. Criminal penalties generally a person knowingly violates Title 49 U.S. Standard Code 5104B with the warrant statute 171.21 of the title you willfully, recklessly violates requirements of the federal hazardous material transportation laws of regulation, order the special permit the approval of the issue throughout there under to be fined with under Title 18 of the United States Code imprisonment not more than 5 years of both, except the minimum amount of the imprisonment shall be 10 years in case in which the violation has involved the release of the hazardous materials which result in death or bodily injury to any person. Alright, 209-133, referral to prosecution. If the inspector included with the certified state inspector of the 212 of the chapter and another employee of the FR becomes aware of a possible knowing violation, Title 49, U.S. Standard Code 5104, with the willful, reckless violation of the federal hazardous material transportation law of regulation, and it should be done with the laws of the FRA, extra the enforcement responsibility that should be reported with the Chief Counsel, the evidence of the existing and tending to establish the prima facie case for the impaired of the assessment of the civil penalty would not be the act with different, but the future violation. The Chief Counsel referred to the report, determined justice of the criminal prosecution order, subpart C, compliance orders. Or subpart C, compliance orders. 209-201.